show up in the corner one.
I'll go back to the Zoom screen.
Since we're live. We welcome you a little after 9 o'clock on the 2nd of February, 2022. This impromptu setting of the 7th Court of Appeals. I want to thank Lubbock County, but especially Judge Les Hatch for loaning us his courtroom, the 237th District Courtroom. We do appreciate it. This is what happens when you live in West Texas and the weathermen are not clear exactly what's going to happen, and we're not clear either. So we thought do something a little different because we wanted to have a live in-person argument. And again, we appreciate Judge Hatch for allowing us to commandeer his courtroom for an hour. We'll go on and call the case. We have one for this morning, and I know that the attorneys have argued in front of us a number of times, so they know all our admonitions. We'll dispense with those, but I will ask for announcements. And got confirmation from our Amarillo clerk that everything's going well. So he's monitoring us. So we'll call for announcements and just give us your announcements and we'll proceed from there. The case we have this morning is 07-21-00144-CV in re the commitment of Robert Cook. And Ms. Clayton, you're for the appellant.
Allison Clayton, present ready for the appellant, Robert Cook.
Thank you, Mr. Ford.
Jeff Ford with Lubbock County DA's office, president, ready, Your Honor.
Thank you. And for those online, if you look at the bench, you may see a placard that says Judge Hatch. The young lady that is sitting behind that placard is Justice Parker. It's not Judge Hatch, so there should be no confusion as to that. And to my left is also Judge Larry Doss, and I'm Brian Clayton. Ms. Clayton, you got the floor, and I'm going to turn on my phone timer. Okay. Let's see if I can. Whenever you're ready.
Mr. Chief Justice, and may it please the court. My name is Allison Clayton, and I'm here on behalf of the respondent, Robert Cook. Whenever I was in the 8th grade, athletics was a requirement for us. Now, I'm from a little town called Earth, and in Earth, Texas, girls' athletics selections are slim. You have basketball in the winter, track in the spring, and full disclosure, I am terrible at both. I absolutely hated it. One of the reasons why I hated it was because of my coach, Coach Bodie. Coach Bodie was a very traditional kind of coach. He was kind of rough around the edges, kind of mean to the nerds. He didn't have much use for me and I didn't have much use for him. So one day on a very rare occasion.
You had a brother in El Paso, I think. That was my coach.
I hope your experience with him was better than my experience with mine. So one day I'm running during a scrimmage, and as usually happens when I run, I tripped over my own 2 feet. Something in my ankle popped, I go down to the ground. I'm on the ground holding my ankles. Coach Bodie sees me, comes over, he looks down at me. He says, what's wrong? What are you doing? I said, Coach, I was hustling so hard, I think I broke my ankle. He looked at it, he says, you'll be fine. Walk around the gym a couple of times, walk it off. I didn't feel fine. So I snuck off to the nurse. The nurse looked at it and the nurse said, you sprained your ankle. You need to elevate it, stay off of it, put some ice on it. I had before me a medical problem. I had 2 opinions, the opinion of a layperson, my Coach Bodie, who said to walk it off. And I had the opposite opinion from the nurse who said to stay off of it. What opinion should I take? What should I do? What would you do? If you're in the gym working out and your knee messes up, are you going to go ask the guy who can do 100 push-ups what's wrong with your knee? No, you're going to go to your doctor. You're going to ask your doctor what's wrong with my knee, because a medical problem that requires medical treatment is only proper for a medical expert. The opinion of a lay person is not relevant. Civil commitments are based upon a medical determination. Civil commitments themselves are a form of medical treatment. That's why when we're making these determinations, we do not ask lay people what they think about it, because their opinion is not relevant. And yet, when the court below committed Mr. Cook to inpatient treatment, it relied solely upon the testimony of laypersons. And in fact, it
Are
relied,
layperson's testimony not relevant in all circumstances, in your view?
yes,
The elements that needed to be satisfied in order to have this commitment, what were they?
the elements are set forth in section 574.034D of the Health and Safety Code. Subsection A of that section says that you have to have clear and convincing evidence that the person is mentally ill and that as a result of the mental illness, he poses a risk of danger to himself or to others, or that he's in some kind of serious distress. Then in subsection D of that section says that clear and convincing evidence must include expert from a testimony and must include evidence of a recent overt act or a continuing pattern of behavior.
So you don't think lay testimony would be relevant to recent act or continuing pattern of behavior?
You see, there's a difference there. So yes, it may be relevant, but is it permitted at these hearings? The answer to that is no. And I think the reason for that is because of the way the statute is set up by the legislature. The statute doesn't contemplate layperson testimony, and only
Where
contemplate.
does it say in statute, no layperson testimony?
It does not say that in the statute.
This says the evidence must include expert testimony. It doesn't say it's solely based on it. That seems to suggest that expert testimony among other things.
It does seem to suggest that. That's one of the reasons why we're here. And it's not really the dispositive issue in this case, but it's certainly an important issue that needs a little bit of resolution and some guidance from the court on. And if you want to get the answer to that question, I would direct the court to section 574.031, D1 and F. So D1 says, as Justice Doss points out, you have to have expert testimony. The clear and convincing evidence, the body of evidence must include expert testimony. That's subsection D1. Subsection F says, in addition to that, and we'll come back to that phrase because it is a very important phrase, in addition to the expert testimony, the court may also consider the testimony of non-physician mental health experts. And there's a statute that sets forth a list of who these people are, people like social workers, psychiatrists, registered nurses, people who are still clearly professionals. Nowhere in there does it say that the court may consider the testimony of anyone with relevant information.
Where does it say in that statute that the court cannot consider that testimony?
It does not say that.
So it's silent on it.
It is silent on it. So that's the reason
When
why.
is expert testimony normally needed?
Did you say when is?
When is expert testimony, in a general sense, not necessarily in the commitment situation, but in a general sense, when is expert testimony normally needed?
Whenever you have an issue requiring some kind of expert knowledge.
Something out of the realm of the normal layperson?
Yes, Your Honor.
Would mental illness be that?
I think the legislature has dictated that it is. Yes.
Okay. So is that why they're indicating we want to make sure there's expert testimony when you're guiding, when you're talking about mental illness?
I do believe that that's why they say that. And the reason why I say that is because if you look at the overall purpose of the Health and Safety Code of Chapter 574, which is the civil commitment provision, the legislature says the reason why we civilly commit people is to get them medical treatment. It's not to punish them for anything. It's to get them medical treatment.
Well, the procedure used in this case did a complete end run around the Constitution and the provisions, not only in Chapter 574, but as set out in, what was it, 46?
46B.102 and 103 are the two.
Right.
Right.
So do we have is medical testimony required? Number one, because if you get medical testimony and then you're going to ignore it, and proceed with it, what does that speak to in terms of the statute and the constitutional?
So you have a couple of things there. Primarily, this is actually a really easy case, and you've hit right on it. There's a constitutional provision that is directly on point. It's Article 1, Section 15-A, and it says a person may not be committed except on competent medical or psychiatric testimony.
Well, isn't that even contemplated under the provisions of 574
It is.
as a preliminary matter to get into court?
It is. So in order to get into court, before you can even have these hearings, you have to have two what's called CME, certificates of medical examinations, and those can only be filed from experts. You don't have those for those two things from an expert, from two different experts. You're not going to have the hearing in the first place. Now, then the problem, whenever the case was in the trial court, was that it became a matter of statutory interpretation. So that whenever 574.034D says there must be expert testimony, does that mean
But you had expert testimony.
exactly? But does that mean that as long as you have an expert on the stand and he testifies, you've checked the box and you can move on?
When that's just it. What did the experts testify? You have expert testimony. And you're originally saying you got a limit on expert testimony. So with regard to the lay people cannot testify in order to give the background, in order to set up the acts that would allegedly show a practice over a period of time to help satisfy at least that one element in the statute.
Well, they could, but it wouldn't have been proper because their testimony shouldn't be at these commitment hearings in the first place. All of
The
that.
medical testimony to begin with was subject to a motion to dismiss because it didn't, for this procedure, it might have very well been relevant, but the way it was utilized here, it foreclosed the opportunity under 103, which this case fits into 103.
See, and I'm
kinda,
not
doesn't it?
entirely sure it does. I'm not entirely sure that it does foreclose it because
Well, you're not able to utilize least restrictive means from the get-go because we're only proceeding under a statute which requires inpatient commitment, not any outpatient.
yes, that's exactly correct. And that's the point of the whole third issue in the brief is that was erroneous as well, right? Because the medical experts and their CMEs and then Dr. Butler at the hearing are all saying, we don't think this man has mental illness. We recognize that at some point, some other expert somewhere along the way diagnosed him with this thing, but we think that if he does have mental illness, which is a big if, that it is most definitely in remission. So from the very beginning, by proceeding under 46B.102, which is the mental illness provision, which gives you the most restrictive means of treatment, instead of proceeding, that's the provision under which the trial court proceeded. But that was erroneous because the experts are also saying this man may have mental illness. He is definitely intellectually disabled.
Let me ask you this. We obviously know that your client started this process back in 2019, when there was a question about possible mental illness, possible intellectual disability. And I think the statutes treat those two conditions as separate things.
Yes.
Then it appears he goes into treatment in Vernon. He comes out of Vernon. Then there's a question in both parties' briefs about him being decompensated.
Yes.
That we don't have any of that in the record, so I'm trying to understand what's going on here at this point.
And
Tell me what you mean by decompensated.
you're asking me what.
I believe it was in the state's
It was.
brief, to be fair to you, but I'm trying to understand, was there something else with his intellectual disability that's not in the record before us, or is there something else we're dealing with here?
No, not that I know of. All of those concerns about decompensation, about him, about Mr. Cook going out into outpatient treatment, and that he'll suddenly go off his medication and he's going to have all these problems, that is sheer speculation, complete speculation. As far as I know, from what I've seen, from all of the record evidence, that's all I've seen is the record evidence. There's not a single expert who's worried about that. And in fact, as soon as Mr. Cook was put on the treatment back in 2019, 2020, he has been consistent in taking it. He's been good. There haven't been any problems with him.
Because
Well, there's some confusion because in your brief, you state, on page 4, that appellant remains not competent.
Right. So this was something that
So can you explain that?
hopefully, this was something that I had to learn too whenever I was coming in on this case, because this is by far not my area of expertise. But it is entirely possible for someone to be not competent to stand trial, but also to not require full-blown civil commitment, right? So you can have somebody who is intellectually disabled, who is able to, work a job, kind of live with some degree of freedom and with a good deal of oversight, but still free, but who still does not understand what's going on in the courtroom proceedings, can't really.
But that's why he was committed initially. He was
Yes.
committed initially for that same reason, that for, again, maybe not for mental illness. That was something that we can talk about, maybe may have developed or may have been recognized later on when he went to Vernon in the first place. But if the intellectual disability was what made him unable to understand the nature of the proceedings against him and required his hospitalization in Vernon, do we really have reversible error here, or is it harmless if you're conceding that he also had an intellectual disability? Wasn't that one of the range of opportunities that the judge had when making his decision?
It was part of the range that the court could have done. It erroneously did not fall under that. And it is nevertheless reversible error, because what the court ended up doing was the most restrictive kind of commitment for someone with clear-cut mental illness. So it's most definitely reversible error, because Mr. Cook is having to go to inpatient treatment at the state hospital, as opposed to being an outpatient treatment, working a job and having some degree.
That's
of
where he
freedom.
is right now.
He is in, he's still in jail, actually. I don't know, don't quote me on this, it's not on the record. But last I heard, he was still in jail and he hasn't even been able, like the state hospital hasn't come to get him from this civil commitment.
And
Okay,
you,
so was there a finding, he was deemed competent to stand trial and brought back?
No, so the way that it works, from what I understand, is he's sent off to the state hospital and they say, we think that we've done what we can for him. We think that he is competent, but competency is actually something only a court can find, right? A doctor can't say this person is competent. The doctor can say, we think this person is competent. That's a legal determination. So they sent him back to the trial court, and the trial court says he is still not competent. And the treatment for that incompetence, that incompetence, is that we're going to send him back to the state hospital. Why you would send him back to the state hospital if they can do anything different for him? That's beyond my area of expertise. I don't know. I don't know what they do at the state hospital.
And that would be through the procedure that was utilized here.
Yes.
Okay, because the order that Judge Eichmann signed in April of 2021, I'm not sure, it was unclear in the record what preceded that. But the order, he doesn't check the box.
Right.
As to whether the defendant remains incompetent.
Right. It is my understanding that the defendant does remain incompetent. And I know if I'm wrong, Jeff is going to correct me on it. But no, it's my understanding that Mr. Cook remains incompetent, but that the treatment for him is outpatient treatment, not inpatient treatment. And of course, there's a huge difference.
And that's what
between
the experts recommend in
Yes.
this case.
Yes, that's exactly correct.
What does Article 46 B073 say? Does it restrict it to outpatient treatment if he's incompetent because of intellectual disability, or can he be committed to a residential care center or a mental health facility as an inpatient, as he was in 19?
I think the answer, if I'm understanding your question correctly, is yes. I don't know if it was a yes, no answer, but that's what I'm going to go with, is yes. So if you go under 46B.103, that's the provisions dealing with intellectual disability, someone who is ID. Then you start out with residential treatment. If in the course of residential treatment, which is a far different thing from state inpatient, state hospital treatment, is what I've been given to understand, that if you're having problems with him there and he is not improving, or if the treatment is just not working, that at that point, his doctors can file a motion. They can file whatever it is they file with the court and say, hey, court, we think he needs further treatment, more treatment than what we can offer here. And the court can look at him again, look at the defendant again and say, you're right, residential treatment's not cutting it. We need to switch to inpatient treatment. But even then, when you're going to do that, when you're going to make that switch,
That's incompetency still for intellectual disability or something like that.
yes, I do believe that's permitted in the ID statute. For sure, that's what you use whenever you're going into the mental
So
illness
it
statute.
can happen that you get commitment more than residential commitment for incompetency based on intellectual disability. In your view,
I'm not sure I followed along with the question. I think
I think that's what Judge Doss is asking. Why was he committed? Well, he's mentally incompetent. No, he's intellectually incompetent. Well, if the evidence shows he's not mentally incompetent, but he's intellectually incompetent, can he still be committed?
I
If
see.
the answer is yes,
I think so.
then is the resolution no harm, no foul? I don't know if it's standard views of recent discretion, but if the court arrived at the right decision for the wrong reason, is there harm? And I think that's what Judge Doss is
I
asking.
understand what you're saying. And the answer is, yeah, no, there's absolutely still harm with that, because if he's intellectually disabled, we know
You have 2
from,
minutes left.
thank you. We know from the statutes that if you're intellectually disabled, you must start, and this is clear within the statutes, that once you hit that ID classification, that you have to start with the least restrictive means. So assuming that the court didn't proceed under intellectual disability, the court proceeded under mental illness. So that in and of itself is a problem, but you have to at least start with him in an outpatient treatment program. You don't just get to hop straight to inpatient treatment, right? And that's what the trial court did, is just hop straight to inpatient treatment. That's the harm in this case, is it should have started with outpatient treatment, which is what all of the experts were saying should be done in the case.
There has to be a present finding of mental illness under the statute.
So under 46B.102, if the court thinks that this person, the proposed patient, may be mentally ill, then they have to conduct proceedings under that, under the provisions, under the mental illness provisions, which
The court doesn't get to choose.
so it's not really clear in the statute, because if you look at the sister statute, 46B.103, it also says if it looks like the proposed patient may have ID, then the court shall proceed under the ID statutes. And there's no guidance, as far as I can tell, to the trial courts as, well, what if this person may have both? What do you do then? That's when you have to fall back on the policy considerations of, you start with the least restrictive means.
You have about 30 seconds.
Thank you so much. As usual, I didn't get to talk about anything that I had planned on talking about, but I'm so glad that we got to talk about this. But I would be remiss if I didn't point out that really, this is an easy case. We have a constitutional provision that is directly on point, that was not followed, that is dispositive. Frankly, it's dispositive. You cannot commit a person except on expert testimony. There is no expert testimony in the case. It is an easy call, and we can figure this out, be done with this, and go home before the snow starts.
Thank you, Ken.
Thank you.
Mr. Ford.
May it please the court.
Why is it when they say it's the easiest case, it always tends to be the hardest?
I agree. I wish I could say that this case were easy, but it really isn't. Here we have a fairly complex record, even though it's a short record, it's a fairly complex record here, because we have an expert witness that the court found credible, but also said that obviously the trial court disagreed with the expert's conclusions here, instead considering lay witness testimony.
So let's start there.
Yes, Your Honor.
My understanding from reading your briefs is the state's position is the court does not have to rely on the expert testimony. We merely have to put an expert up there to offer it.
Yes.
So obviously, we're going to have to write an opinion on this, and this opinion may instruct other prosecutors down the road on how to address this issue in the future. Where would the state have us draw the line on what is required when a case is called to put an expert up on the stand? You call them and say, what is your name? I'm Dr. Davis. Thank you. I passed the witness. Is that enough to say the expert is now testified? Or what does the expert have to do under the statute to meet the minimum of what the state believes is required?
I would say that we look at the language of both the Texas constitutional provision as well as the language of the statutes themselves, and they refer to both the constitutional provision and statutes refer to competent medical or psychiatric testimony. So we would certainly have to put on the expert and put on more than just as in your example, just the person's name. Thank you, past witness here. We'd have to put on their expert testimony there, but that doesn't mean that just because we have to put on expert testimony, that the court has to necessarily rely on it.
So they have to offer an opinion.
Yes, Your Honor.
In the state's position, it doesn't matter what opinion they offer. They can say this person is mentally ill, this person is not mentally ill, that the court can then look at other evidence to confirm on its own whether it agrees with the expert.
Yes, Your Honor. Same as in any other case, the trier of fact, whether it be the trial judge or the jury in an appropriate case, gets to determine for itself the credibility of witnesses.
But is it the same as any other case? The standard is incompetency.
Yes.
Okay. Is that a topic within the general knowledge of a layperson? If it is, then I'm incompetent. My kids, my brothers and sisters always said, Brian, you're stupid, you're dumb, you're incompetent. So, but that's my question though. Is that something within the general knowledge of a layperson?
I would argue that certainly whether a person meets the standard for incompetency is not within the general knowledge of a layperson, but the court can consider the expert testimony, even if they don't consider all of it, making the determination whether the person meets the incompetency standard or the civil commitment
And
standards.
there's times when a layperson can testify to something that's normally considered expert, if they've had that experience, training, things like that, or they have experience in it. Correct?
Yes, Your Honor. For example, in this case, Deputy Blissard had testified here, and she meets the standard of being a lay witness as opposed to an expert witness, but she provided competent about testimony.
Was she developed, shown to be somebody that had the credentials, so to speak, of experience, sufficient experience in order to render opinions on one's competency? Or was she a deputy was she the jailer?
She works at the jail and the mental health pod.
Well, is she, okay, I don't want to diminish her status, but is she just a jailer, or was she somebody who did counseling that could give a knowing opinion, an informed opinion of somebody's competency? Does the record show that?
I remember that the record shows that she had training experience, had taken particular classes on mental health, but she wouldn't meet the standard under the statute of competent medical or psychiatric testimony. So she would.
And you said that in your brief. You conceded in your brief that she is not one who would satisfy the definition of an expert under that statute, if I remember correctly.
Yes, Your Honor.
I think there's something that's more important about that witness. Her testimony was restricted to the time period before Mr. Cook was brought in first, right? That wasn't from present day observations. That was from something that happened back in 2019.
Yes, Your Honor, that's correct.
So under those circumstances, that doesn't seem like that would be relevant, because she would not have the present ability to know whether Mr. Cook was competent or incompetent.
Her testimony is competent because, as the cases of LS v. State and Roland v. State make clear, both of which I cite in the state's brief here, you can consider what would happen if the defendant were put in outpatient, if they were no longer being treated, if they get out on the street, they're stopped taking their medication.
Is that speculation, or is there evidence to say that? Do all mentally ill patients who are getting drugs in order to gain some level of competency, do they all give up the drugs when they leave supervision?
Of course not, Your Honor, and I would never suggest that. The reason why the lay witness testimony is so important here is because the expert made clear that he had done 2 brief examinations of the appellant, whereas the lay witnesses were people who had known the appellant for almost their entire lives. And they're one of the.
How many of those lay witnesses had seen Mr. Cook since the time he was discharged from Byrne in 2020?
I don't remember any evidence of any of them having seen him after the time period after he
One of
was
the cases you
arrested.
discussed a minute ago, I think it was Nolan case, but I may be wrong on the style. It did involve a case where somebody took the stand to say, this gentleman is under medication and I don't think he's going to take his medication, but that was the defendant's sister who was taking care of him at the time. Isn't that right? Doesn't that seem to be a different set of facts than somebody who was looking back at what happened 2 years earlier and then trying to extrapolate what they subjectively believe he would do or not do under the circumstances?
The lay witness testimony is still important, critically important in this case here, because they had known the appellant for his almost his entire life, and said that they had known him during the time period where he wasn't taking any medication there, and had no reason to believe that if he were released that he continued taking the medication. They didn't want to be responsible for making sure that he would take his medication. It's one thing if
Did they also testify that he had a few years before or sometime before he was prescribed medication for his mental situation? And then he gave it up, or did they just say he has not taken prescription medication?
Prior to the time period of his arrest, he had not sought any psychiatric help for his condition there.
So he's never been prescribed medication.
Yes, Your Honor. And it's one thing if someone's in a secured setting, like the mental health pod, where somebody can ensure that that appellant is taking his medication. It's another thing where he is entirely on his own. But prior to his arrest, his family didn't want anything to do with him and took him to Tent City there. He would not have any supervision there, nobody to make sure that he would be on his medication.
How are we able to test the basis then of somebody's knowledge? Certainly within the context of an expert, there are tests that people bring under Rule 702 to test whether or not somebody's expert opinion is formed based upon accurate facts and is using, proper analytical process without a gap. When we're talking about these lay witnesses who are saying, I don't think he'll take his medication if given the opportunity to do so, but have no present experience with whether he actually would or not. Does that constitute evidence that we can consider, or is that just speculation that we have to write off as no evidence?
I believe it constitutes valid evidence of the case based on their lifetime and knowing him there. And of course, not only their testimony about whether they would want to be responsible for him or giving him medication, but also the testimony about the recent overt acts, about the continuing patterns of behavior. What had he, what their knowledge was of him over the course of decades there, about his repeated sexual abuse of his brother. And then the victim in the case, TS, just use her initials for purposes of this, as well.
What's the definition of recent? Because those are allegations that were 50 years, 4 years, and then at least more than 2 years.
There is no definition of recent for purposes of the statute there. What I found from dictionary definition is recent overt act means an act done just prior to the present time that can be objectively perceived and to some degree probative of a finding of serious harm here. There is no definite time period that can be done in there. Recent can be recent months, recent years here. There is no definite time period set in there.
Recent decades.
I don't believe that I believe that decades wouldn't qualify as recent for purposes of this here, but as the trial court said here, you can certainly consider recent as encompassing the time period just prior to the appellant's instant incarceration, which has been ongoing since the time of his arrest here.
That's 2019.
2019, yes, Your Honor.
But it's not recent in a vacuum by itself, or a recent overt act. It is a recent overt act that tends to confirm the likelihood of serious harm to the proposed patient or others.
Yes, Your Honor.
So it is not simply this individual did something that's in the recent past, but it has to be something that confirms the likelihood that it's going to occur again in the future.
Absolutely, Your Honor, and that's why the
What
testimony.
evidence of, you mentioned sexual assault just a minute ago. And I believe there was another allegation of a sexual assault from the 70s, and certainly I don't think that's a recent act. What evidence of a recent overt act of sexual assault would confirm the likelihood that it's going to occur again? Not the possibility, but the likelihood under the statute.
I'm sorry, Your Honor, I'm not entirely following the question.
What was he arrested for?
He was arrested for aggravated sexual assault of TS.
So you got a purported recent act of sexual assault. And then you have other evidence of sexual assaults.
Of his brother. Yes, Your Honor. Although I wouldn't argue that those are recent here, and that's why it's important to consider the continuing patterns of behavior portion of the statute as well. Even if something isn't recent, if something has been ongoing for a long period of time here, the court can certainly consider that as continuing patterns of
It's
behavior.
kind of like building a chain.
Yes, Your Honor.
You go back far in time for the first link. Is this what you're saying? For the first link, so you can use an event that happened 50 years ago and then start tying it into other events that maybe 45 years ago, 40 years ago, 35 years ago, all the way up to the time of arrest.
Absolutely, Your Honor. Yes.
Okay. Do you have those intervening events? Judge Parker mentioned the event that was 50 years old, I guess the assault of the brother. And then the one preceding the arrest now. Are there other events that indicate sexual behaviors, deviant sexual behaviors or something along that line?
There's evidence that he was abusing his brother in their youth and continued in his 20s there. And then there is an evidence for a gap of time there that he was sexually abusing anybody there, but then it continued in the not too recent past with sexual abuse of TS here. So we can consider that as continuing pattern of behavior in sexually abusing people there. And of course, we don't only have to consider the sexual abuse evidence here. We also have the evidence of we also have the evidence of suicide attempts here on the two separate occasions here in the record. He has attempted suicide.
But none of those occurred after his treatment the first time, his first treatment, right?
Correct. Your
So
Honor, they all
we're
occurred.
talking about something that is more than 2 years old.
Yes, Your Honor. That's correct.
How do we determine the likelihood? That's what the statute requires, the likelihood of serious harm to the proposed patient or others. Doesn't that seem to be something that you would have to have an expert say, based upon the information I have, it is likely that this individual is going to harm himself or others? Or do we allow lay testimony to speculate on that?
I think we can absolutely allow lay testimony on that, because we don't only have to rely on the lay testimony here. We can also rely on the expert testimony here. Even though the expert, Dr. Butler here, ultimately disagreed with the ultimate conclusion, he still gave evidence that was a link in the chain there. He talked about how the appellant had been treated both for psychosis and for depressive disorder, and was continuing to be treated for that, even though he disagreed with the ultimate conclusion of psychosis. Even Dr. Butler admitted that he was still being treated for psychosis.
Well, he also expressly disagreed with the question of whether Mr. Cook was likely to cause a substantial risk of serious harm to himself or others. He was asked that question directly by the state and said, no, he doesn't pose a risk.
He did, Your Honor, but expert witnesses are not infallible. For example, in Ms. Clayton's discussion there about her ankle there, what if instead of the nurse saying that she needed to lay off, what if it had been the coach who said that? Which one would she have to state then? Just because the nurse is the one who said that, nah, it's fine, you don't have to do anything. And if the coach had been one saying lay off of it, then certainly she would be right in giving more credence to what the coach had said as opposed to what the nurse had said. just because the person has a PhD or MD to their name does not mean that they are infallible. They're still capable of making mistakes. And
So
that-
would you disagree then with the constitutional provision that says you can't require somebody to undergo inpatient mental health treatment, essentially, except on competent and credible psychiatric testimony? I think that's roughly what it says. The phrase says except on. That tends to indicate that, at least from the constitutional perspective, the expert has to agree with the assessment.
I certainly agree that the constitutional provision and the statutes require competent medical and psychiatric testimony. As you said, it says no person shall be committed as per unsound mind except on competent medical or psychiatric testimony. But we had competent medical or psychiatric testimony here from Dr. Butler.
Yeah,
This-
and I'm trying to restrict that to except on. It has to be based on it, doesn't it? Isn't that what the provision is saying?
I believe what it's saying, both from the constitutional provision and the statutes themselves, are saying that there must be psychiatric or medical testimony introduced in the record. That doesn't mean that the trial court needs to agree with them, because that would violate the trial.
Are you suggesting that the trial court, and I'm sorry, Judge Parker, I know that you have a question.
Oh, well, I was just gonna say, with regard, isn't it a threshold issue with regard to the CMEs that under, if it applies, 574.011, that certificate, the statute seems to require the examining physician's opinion that the examined person is a person with mental illness, which Dr. Butler disputes. As a result of that illness, the examined person is likely to cause serious harm to himself or others, or is suffering severe and abnormal mental, emotional, or physical distress. And then it goes through several other criteria. The CMEs we have here, they didn't check the box.
You have 2 minutes, by the way, Judge.
Thank you.
And so isn't that a safeguard for the constitutional provision stating that except on competent psychiatric testimony? Isn't that why we have this in the statute? And it seems like it was just, we got them, they were signed, they weren't filled out, or the boxes weren't checked, but yet we're proceeding.
And that's why I believe both what happened in the pre-hearing and during the hearing itself is so important here. As previously noted, if it appears that the defendant may be a person with mental illness, then the court is required to proceed on the mental illness statute. And that's what happened here, because while the CMEs did not have that portion filled out, as you noted there, the pre-hearing representation showed. Thank you. The pre-hearing representations showed that appellant may be a person with mental illness. So the court was required to proceed with a mental illness hearing here.
I'm sorry, the pre-hearing what? I didn't-
The pre-hearing representations made by the state, Your Honor, talking about whether the state can meet its burden here. And then, of course, the state put on Dr. Butler's testimony and the testimony of lay witnesses here. So it's not just saying whatever the expert witness says we have to agree with is an any sufficiency challenge. The totality of the circumstances here and the totality of the record here show that appellant is a person with mental illness, and as a result of the mental illness is likely to cause serious harm to himself or others. And I'm sure I'm out of time. I'm almost out.
You had 8 seconds.
Well, so does the statute say suffering from a present mental illness, or is it just if there was ever a diagnosis?
What
And
is
there wasn't any intervening diagnoses?
what it says is, as a result of that mental illness, he is likely to cause serious harm to himself or others. And that's why I believe it's so important to consider what would happen if he were released from this secure setting that he is currently in.
Your time has expired, but let me see if the judges have any other questions.
Nothing else.
Because I do. And it's something with relation to what Judge Doss asked opposing counsel. And first, I'm going to ask you, you probably covered in your briefs, I just don't remember. What's the standard of review?
Standard of there's of course the sufficiency standard review, and then abuse of discretion for the first issue. Then the other issues would be abuse of discretion.
You say sufficiency and abuse of discretion. Is the sufficiency part of the abuse of discretion, like in family law and a bunch of other type cases where sufficiency is an aspect of abuse discretion?
It's a standard of, it's a sufficiency review based on clear and convincing evidence standard.
Okay, so it's a pure sufficiency question.
Yes, Your Honor. It's different from the kind of sufficiency that I normally mention, but it's based on clear and convincing evidence.
The other question, Judge Doss was indicating, or asked about whether or not he could be committed for intellectual incompetency, for lack of a better term, mental, intellectual problems. And he was wondering if the state, not the state, but the opposing counsel's position conceded that, yeah, he could have. If he could have been committed for that, we have reversible error. Is it harmless? And that's why I was alluding to the abuse of discretion, because under that standard, it doesn't matter whether or not the reason is right, as long as the decision is considered right, so to speak. What is your view on that?
I think there's certainly an argument that it could be harmless error, because the appellant would still be required to go through much of the same standards as he would if he as under the mental illness standard. Though I'll admit I haven't read enough on the intellectual disability side to say for certain whether it would be a harmless error or not.
Do you recall if there was any evidence presented at the hearing about intellectual disability, or if the evidence or the testimony was specifically focused on mental illness?
Dr. Butler said that he believed that appellant's primary diagnosis was intellectual disability there. And then, of course, the state talked about the medical records showing the psychoses and the major depressive disorder.
I asked a bad question. Let me ask a question, hopefully in a better way. Was there any testimony about whether Mr. Cook understood the nature of the legal proceedings, role of the prosecutor, role of the jury, things like that, when he had been assessed in the state mental hospital and Dr. Hernandez had reviewed him then, if those types of questions were presented at the hearing?
If there were any, I don't remember. I don't recall this being asked, Your Honor.
So is the state's position that the medical records would supplant the testimony of Dr. Butler?
To the extent of disagreeing with his ultimate opinion, yes, Your Honor, but there are certain portions of Dr. Butler's testimony that support the mental illness diagnosis, even though he disagreed with the ultimate conclusion.
Thank you, counsel. Your time has expired.
Thank
Any
you.
other questions? Thank you, counsel. We took the state over as 20 minutes, and if our questions take you over the 5 minutes, you'll be given the additional time too.
I will stay here for as long as I want to talk. Let me first and foremost address the harmless error issue, because I think I'm concerned that it's not clear. If somebody is determined to be ID, they have to go with the least restrictive treatment option, which means they're going to go into, I don't know, whatever
Define ID.
intellectual disability. Then they'll go into like an outpatient treatment type facility or a residential care facility. In order for them to end up where Mr. Cook is headed now, which is state hospital, you still have to have a medical expert come in and say, we have to transfer him out. That does not happen. You do not go into a state mental health facility unless an expert says you need to go into a state facility.
The reason I asked the question, that's not how we got there the first time around.
That's right.
Mr. Cook had been charged with a criminal offense. He was trying to consult with his criminal defense lawyer in preparation for his defense. She files a motion with the court, correctly, I believe, saying, we don't think this guy understands the nature of the process. The next thing we know in the record is he ends up in Vernon. So we don't know what the other portion was that led up until that date on other things that were tried. But we do know he was treated in Vernon. And we do know that during his treatment in Vernon, he took weekly classes where he was taught what the process was about and appeared to respond favorably over time to understanding that process to make him intellectually competent to undergo trauma.
That's right. And I think it's an important distinction that we have to keep in mind, that There is a difference between competence to stand trial and someone who needs to be sent to the state hospital. Just because somebody is not competent to stand trial does not mean that they have to go to the state hospital for treatment. And that's kind of where Mr. Cook falls. The next thing that we need to talk about is,
But we have, and I apologize
No,
for cutting you off.
I'm here for you.
We also have to be mindful of the fact that the consequence of saying that there is no evidence of mental illness would be to set this matter for trial.
Not necessarily. I mean, I don't know, honestly, I don't think that that's actually correct, because if there's not the mental illness issue, just because you're not mentally ill doesn't mean you're competent to stand trial. So for example, with Mr. Cook, he's definitely intellectually disabled, doesn't mean he's competent to stand trial. Like, there is a very important difference between the two. But we really don't ever need to reach that point. This really truly is, like, I'm not being facetious. This is a really easy case. This should be a very easy case to decide. Words have meaning. The Texas Constitution says you do not commit someone except on the expert's testimony. And it doesn't say, as long as we hear from an expert, it doesn't matter what the expert says, the trial court can supplant the expert's testimony for an opinion of its own. We know for a fact that the fact finder can't do that. The Court of Criminal Appeals told us that in the Petitone case not that long ago, that death penalty case at the end of 2021 from Justice Knoll, or from Judge Knoll. It's at 622 Southwest 2nd, 534. Actually, it's at 321 and the relevant portions at page 360. And it says that a fact finder, if you're going to make any kind of expert determination, they are not an expert. They have to have an expert. So if you don't believe that expert, fine, find somebody else. Get a different expert to tell you something different. But the trial court does not get to come in and play chief doctor. Lay people don't get to come in and say, well, I knew this person 20 years ago. I knew this person 2 years ago. I have zero medical experience, but I think he's a bad guy. And we need to make sure he stays locked up. So just figure it out. Figure out how we're going to keep this guy locked up. And then the trial court comes in and says, okay, fine. Even though there's not a single expert that says that he needs it, we're going to send him to inpatient treatment. That's simply not how our system works. We're talking about taking away somebody's liberty because they're not as smart as us or because they're sick. And that's simply not what we do. We don't do that kind of thing lightly. We only do that if an expert says it. And there's not a single expert who says that Mr. Cook deserves that. Every single expert says that what he needs, medically speaking, is outpatient treatment. And when the trial court said otherwise, it supplanted the medical expert's testimony. And that was erroneous, plain and simple. There's a Texas constitutional provision directly on point that I guarantee you, if they had known about it at the trial level, we wouldn't be here today. And that's an indicator of just how dispositive that treatment is. Whenever I sprained my ankle and I went to the nurse, she didn't call up my 6th grade math teacher and say, hey, how did Allison do in math class? It's important for me to know for treating her sprained ankle because it's not relevant. It's not relevant. What Mr. Cook did, all of that layperson testimony was not relevant to his medical needs. None of those people knew him on medicine. He had never been medicated. Every single person who knows him on medication says he needs outpatient treatment. That's what we should be doing, is what the experts say. It's what the Constitution requires. It's what our statutes require. And because the trial court acted in contravention of the medical experts, reversal is required. Thank you.
Questions? Thank you, Council.
Thank you, Your Honor.
The case is submitted and you will be excused to leave. I want again to thank Judge Hatch for allowing us to use his courtroom here for this impromptu oral argument. I want to thank counsel for appearing here and orally arguing. I think given the tenor of this case and the nature of our questions, I'm not sure the exchange could have proceeded as smoothly as it could have over Zoom. Though Zoom is a good alternative. So we do appreciate your willingness to appear under these circumstances.